colleagues, welcome to our meeting. We are here. I am Adrian Nizorov,
I'm Anthony Indrishak.
and this is our American friend.
Michael Gilman.
Hello, and we're here to celebrate anniversary of American independence, 250 years from the signing of Declaration of Independence, and to discuss the role and the impact of the United States in the global process of forming intellectual property regulation, forming intellectual property legislation, and so discuss and ask Mike some amazing and some risky questions about American role in intellectual property law.
And of course, we started with McDonald's because McDonald's is one of the greatest intellectual property things America ever created. Broadly.
Sure. No, McDonald's, but the whole franchise system, which tries and to arrange royalties, payments to American owners from different regions of the world, from Serbia, France, to Australia, and to other countries. So let's start from
Scratches.
From scratches. What do you think, Mike? If we know that, at least from our European part of the world, we know that America declared its independence from United Kingdom, from British Empire, and the main topic of their independence was the Boston Tea Party, and they said that they don't want to be in line with British monopoly on trade, and they want their own system, they want their own intellectual property system. And do you think it is okay that they, apart from English monopoly, but establish their own monopoly, intellectual property monopoly, because intellectual property is something like when I have exclusive right to produce the Mark, for example. What do you think?
Well, I contest the fact that the American Revolution was based upon wanting our own monopoly system. It was to get out from under the king and the taxation, and not having any representation over in the United Kingdom. And we were paying all these taxes. And so that's my understanding of the reason why, one of the main driving forces. I've read a bunch of American history. I never remember intellectual property ever coming into the as a cause for the American Revolution.
But it was in Declaration of Independence. It was an American Constitution, right? So it was one of the fundamental principles that we are protecting intellectual property.
Intellectual property is definitely codified in the Constitution for inventions and works of art, so patents and copyrights. And that's certainly, but we got to remember, as a UK territory at the time, all the laws in the United States were based upon the English system. And so it makes 100% sense that our laws were established, many of which similar to the system of the United Kingdom at the time. And I presume the United Kingdom had protection for intellectual property. If they didn't, and we just put it in, we put it in because we wanted to give protection and incentivize creation of inventions. If you create an invention and you can't protect it, then you have a lot less people creating things. So in order to protect that and encourage invention, we put it into the Constitution.
But why trademark the missed? Why do you think Constitution and founding fathers missed trademarks in the Constitution?
Trademarks were more created for the protection of the consumer, to be quite honest with you. I mean, let's face it, everyone. Raise your hand if you're just an ordinary idiot consumer. All right? I mean, we're not that bright, right? So if you start buying a brand and you like it, the next time you go to the store, if there's somebody imitating that brand, but it looks the same and it's got the same name, you're going to buy that. And if it's not the brand that you wanted. And so in order to protect consumers against that, trademark law was primarily created. And I think in general, it's a well-regulated, well-done system. The whole system of for example, ICANN and domain names and internet websites really threw a monkey wrench into that whole process for many years. Now, X number of 15 or so, 20 years later, it's a much more understandable and protectable area, and you can protect yourself in the internet much more easily than you did at the very beginning. At the very beginning, it was a very anti-trademark aspect. And actually, when at the annual INTA conventions, International Trademark Association conventions, they would often have discussions and meetings and representatives from ICANN there. And that actually upset me because I was just angry at what ICANN was allowing and how it violated the trademark owner's rights, and how difficult it was to police that and keep that under control. But again, as they say, time heals all wounds, and it over time has gotten fixed, and it's an acceptable working system. Anything new, such as AI, is right now with respect to copyrights and patenting. It's a brand new thing, and it's going to create and is creating waves all across the world. 20 years from now, it'll be a non-issue any longer.
So you actually think that at the moment when the United States announced its independence from the United Kingdom, the trademarks was not really the problem, and because there was no such a trade market, there was no FMCG companies or something like that. There was a small shops in small cities across the whole United States, and that's you probably could have a chance to face this problem with delusion or something, or confusion, but not so much that it happens right now.
Well, no, nothing is as much as it happens right now, but in the United States. But back then, actually, the people who might have been getting hurt from the failure of enforcement of trademarks would most likely have been the British companies. Probably in a lot of the cities, there were stores. I mean, there were clearly stores, and a lot of those probably were British brands. And so now all of a sudden you got these colonial upstarts going against the crown, and what's my brand what's gonna happen to my brand? But it's the British brands that are probably getting more injured. I doubt, I don't know, somebody look this up. I doubt there were many at the time of the American Revolution, there clearly had to have been U.S. stores and brands that had started. I doubt any of those ever made it over to the U.K. at that time.
True, yeah. But okay, then I have a question, an imperialistic question. If the United States, first, when they declared their independence, didn't put the trademarks because they wanted to incentivize the local producers or local shops, and to create some damages for British companies, like British, it was the British Indian company there, right? Like that. So British American company, I would say. But why now the United States companies can have the more protected brand, like worldwide? There is a lot of things like ICANN, which you previously described. All of this modern technological companies, they like, I don't know, YouTube or Instagram or something like that. They based in the United States, and they tend to promote American law over any other law because they understand this law. And so the trademarks from the United States and, I don't know, patents from the United States and basically everything else from the United States gets practically bigger protection, more powerful protection than the trademarks from Serbia, for instance, or patents from Serbia.
Well, first of all, I don't think that's true. But going back to the original statement, I don't think anybody during the American Revolution
Thought about that.
ever thought about or gave a rat's ass about trademarks and brands. And
that's fair.
and my guess is whatever the British companies were lobbying for, if they were at all, for the king to keep and make sure that the American colonies didn't separate because they were protect. I'm sure that they didn't particularly care. You know, I mean, I don't think that was a really big issue.
Yeah, that's fair. But
Okay. And I don't think as an American, that's an international entity. And I think it's centered in Europe. No?
I'm not.
Let's check it out.
I don't know.
I'm not
I don't
sure.
know.
I'm not sure that.
Again, you guys out there, check us out. You don't know.
Yeah, but actually they. Okay, let's.
Okay,
let's,
so now
let's
getting
put-
back to the last point.
Yeah, let's put that
Okay,
in aside.
yeah.
Let's speak
You
about more
you
YouTube
took
or
me
Instagram.
to
Or
McDonald's
McDonald's.
as an example of American imperialism.
Consumer cultural imperialism.
Okay. I don't see this as any different than protecting the wines from France in the United States
And cheese, yeah, actually. Yeah.
and cheeses. And to try to impinge upon Americans by saying that we're being imperialists by spreading our culture around the world and protecting it under trademarks is, I think, more the result of countries inviting McDonald's in, and inviting Burger King in, and inviting, I saw around here in Belgrade, KFC, and I never would have thought there would be a KFC. there was one.
They're waiting for Taco Bell. So this year, first Taco Bell is opening in Serbia in Belgrade.
So yeah, and look at the excitement in his face about that. Now,
Probably he
why
likes
is that the
tacos.
American person's problem? Because you guys want it and you're asking for it. I don't understand. Why is that a problem?
Actually, it's not a problem. I just try to, think about that. Like all of the small businesses, like from Serbia or from, I don't know, Russia or from Europe or anyone else, they almost every time try to get some intellectual property asset and get it in the United States, first of all, especially for technological companies, because they would.
But they do get it.
They do get it, yes, of
Yeah, so
course.
that-
There is nothing, there is no trouble with that. But no one thinks actually about regional markets. No one cares about that.
What do you mean by that?
Let's assume I am a startup. I own a startup in Serbia, and this is a tech startup.
Mhm.
I don't know, fintech or something, or
Illegal tech.
legal tech. Yeah, legal tech startup. I would think whether I need a trademark in Serbia, and I even would think whether I need a trademark in the European Union, but probably yes. But I'm definitely 100% need trademark in the United States, because trademark in the United States will guard me more. I will have a chance to write to the Apple support or Google support or something like that. Please look, there is an application which is named like my application. Of course, I don't operate in the United States, at least for the first 5 years, because I can skip this part, and I have 5 years to start it up. But I will have a power of a trademark, of American trademark, and Apple will discuss with me. But if I write to the Apple or to the Google support that, oh, let's see, I have a Serbian trademark and there is an application which is named after my trademark, I don't know, 60-70% that they will not answer me at all.
Okay, but when you say answer, because in your scenario, that person is trying to do business with them, or that person saying, we have this trademark and now you're infringing upon our trademark?
Well, yes, some competitor infringer or not competitor.
So Apple is
someone-
let's
Apple
say
is an owner of a store, and someone placed his application into the Apple store.
and it's an infringement of this Serbian company's mark.
Yeah, of my trademark.
Okay. Well, first of all, the first thing that the retailer will do in every single one of those instances is refer you to the manufacturer or the company that sold them the goods. And so the company that put the goods into their store, because I guarantee you there's a indemnification that says that you're liable for any infringements of trademarks of other companies. Now that doesn't mean that the Serbian entity who owns that trademark in the U.S., if and when they sue in court, they can't name Apple and the company. And they will name Apple and the company in most instances. And that gets Apple angry at the company that sold them the infringing good, and puts pressure on that company to settle the case and get it out of court and fix the whole thing. Now, if there were no registration and no use yet in the United States, all Apple is getting at that point is a letter from a Serbian company that may have rights in Serbia, that's never sold the goods in the United States. And it would be no different if an American company in Utah did the same thing. And then, 10 years later.
The application is available from worldwide. Like,
But let's say they didn't file it. But you said they did.
No, application like tech application, like mobile application or something like that.
Okay, but did they get a patent? Did they file for a patent in the United States?
No. They just name it.
They just name it.
Yes.
Is it being used in the United States? You said it wasn't being used in the United States.
It wasn't.
Okay, so then
No, actually, my point is that the American trademark is more powerful than any other trademarks in the world.
For global
Platforms, yeah, actually.
specifically those which are
Which are made
Like
through the
through internet.
internet or mobile applications or websites or something like that.
But again, I don't know. I think that's more political than it is. I just think that's just because of America's position in the world versus many other countries' positions in the world.
Probably no, I would say that it's a legal question because you can sue Apple or Google or anyone in the United States. And you can sue it based on American trademark. But you probably can't sue it from, I know you can sue Apple in Serbia from Serbian trademark. But they doesn't care about that.
Well, but that's just a decision of the company whether or not they want to fight. All of that is an economic decision. I mean, nobody wants to file lawsuits in the United States. They're just very expensive. Nobody wants to file laws, and the rest of the world is not nearly as litigious as United States people are or companies are. So therefore, that company that's in Serbia, if they're not going to want to fight to protect their mark in Serbia against an American violator, right? Is that your scenario?
Maybe that's American violator. Infringer can be anywhere in the world.
Infringer. So then why would this serve? I mean, you live in, or you're going to live in Belgrade. Why wouldn't, I don't know what the laws here are. I don't know how easy it is to protect my trademark right here. And it's worth suing. And I mean, there's just a lot of, America is a suing country. It's horrendous that way. Look at the woman or man, I still don't remember, who spilled hot coffee on herself or himself after purchasing it at McDonald's. And to this day, I laugh about it, and sued and won. I mean, it's just silly, that anybody could win. But it's actually even sillier to me that any lawyer would bring that lawsuit. Yeah, but that's what it is.
But the problem also is in this, let's say, court suits burden, because what is Anton saying? He's saying that if Apple is American platform, so I could sue my infringer with Apple as a co-party of my co-defendant, and so I'm going to American court because I have American trademark. And point is that I need to have that burden of very expensive court case in America. Yeah, and why it is so expensive? Why case in America is so expensive? Why was a jury in America? Why all the questions about intellectual property are decided by jury, even not in trademarks, when confusion and it's potentially could, but in patents.
It's the whole, yes. Is the system, I don't want to say broken, but is it complicated? It is, and it can be a problem. But if you have a situation where, I mean, that's just the way the laws have developed, and maybe it's the you hear about it in politics every 5 years or so about the power of the legal bar, and again, in lobbying, like the trial lawyers bar wants, doesn't want limitations. They want to be able to, and they win a lot on that. And then there are a lot of people that want it to be narrowed so that they can't have such control and have these lawsuits. And that's all just a very political question, and it's done at the voting level, at the voting booth, and who you picked, whether it's the Democrat or the Republican, and then whether or not the person who won follows through on their campaign promises to try to fix all of that. And as Danny is finding out in New York now, as mayor of New York, you can say a lot of stuff on the campaign trail. Go ahead and try to get it passed when you're in power. It's not the easiest thing. It's not the easiest thing in the world. If the American system, why you say trials, and that was always, look, to this day you hear about it. It's you go in and serve jury duty, or you go into court and there's a jury that's being spoken to by the judge, and it's, thank you so much for being here. It's it's one of our most prized duties as an American to come and serve on a jury and support the legal system. And all of that's true and all of that's great until you are the lawyer trying to sue or defend your case in front of a jury, and the most simple cases they're just very, very difficult to try to a case. First, from the very beginning, throughout, we've got to get all the discovery, got to make sure you've asked all the right questions, gotten all the documents. You've got to make sure you take the right depositions and ask the right questions in the depositions. You got to go through all the motion practice of arguing. If you were saying, why is it so expensive? Because these things take years. And you file a lawsuit and most of them will still be around 5-6 years later. It's just the way it goes, because most courts will grant extensions relatively liberally. And the lawyers will almost always be taking advantage of that for various reasons. And so you have these cases extending for a long period of time. Then if you have a dispute over a discovery issue of the document production, then you have to decide, can I work this dispute out? And the rules require us to try to work it out as attorneys. And do I work it out? And as you know, in any settlement, any compromise, the best settlement is when both sides are unhappy, right? Right? So you've got to decide. You come to a point and you make that decision of, is my client happy with this settlement? And the discussion you have with your client is, okay, are you happy with this, or will you want to spend 3 months in motion practice, and depending upon the type of motion, $20,000 to $40,000 more dollars, and here's my opinion as your attorney. You've got to 60-40 chance of winning it. You know, and it's all just a give and take. But the people who do want to fight, lawyers are more than happy to, as long as the lawyer's being honest with the client and telling them their honest opinion and what they honestly think is going to happen, and they're honestly giving them a quote. It's a business decision. They make the decision to go ahead and fight. That's the battle they want to have. Then, you're more than happy as the attorney to go ahead. You file and you have that battle and you see what happens. And then that just delays everything. Because one of those motions can sit with the judge for months and months and months and months and months, where everybody's just twiddling their thumbs, just waiting for stuff to happen.
And what about jury? So, because in European jurisdictions, we almost doesn't have jury for trademark cases, for patent cases. And for me, as a European lawyer, is also a question, for example, why those from jury should decide my case when, for example, it's patent case about some very, very deep technological issues, about very, very complicated questions and so on.
Most of the reasons why you will have a jury in the United States is because almost always defendants don't want a jury. They much rather have it tried to the judge, a bench trial as we call it. But you have a right, as either a plaintiff or a defendant, to demand a jury trial. And if the plaintiff wants it, that's what's going to happen. There's going to be a jury trial. And a lot of times the plaintiff feels, and a lot of that goes on emotion. Am I a small business against a big company? Right? The jury's going to be more sympathetic, more sympathetic to the plaintiff in that situation. Am I, so there's all these things you have to weigh in it. But the unfortunate part, as far as I'm concerned, the unfortunate part is that if the plaintiff demands there be a jury, you've got to go through that. And then preparing a case for a bench trial is still difficult, but it's far easier because many of the issues that come up on evidentiary issues and how you're asking questions to the witnesses, with the jury involved, you've got to have those discussions with the court, because the court wants to make sure that the jury is going to not be prejudiced by these issues or not be and understand the issues. If the jury's not there, the judge just makes the decision. So you basically, if one of these issues comes up, you don't have to have a sidebar with the judge that the jury can't hear. You don't have to take all that time. And you just have the conversation with the two sides, have the conversation with the judge, and the judge right there makes the decision, and it goes forward. The judge understands what's going on. So you can cut down on a lot.
But is it more like for legal tradition because of the legal
Institutional tradition.
Yeah, constitutional tradition, because it's the very, very conservative. Because, let's say trademark case for a trademark infringement. There is one question inside it. The question is whether there was likelihood of confusion or not. So this question is actually good to be questioned before the jury, because jury, they are consumers.
Yeah, they're consumers. Yeah.
But for patent case, there is a lot of technical peculiarities which regular people do not understand, because they are not technicians, they're not engineers, they're not chemical engineers or researchers or something like that. And you have to go through it. It's wouldn't it be, better for economical sphere, for economical view to the business, to exclude those at least patent cases from the option to ask for a jury?
You have a right to a jury trial. So, and in that instance, the plaintiff, even though it's probably a company, not an individual, has a right to a jury trial.
Yeah, but we can
And
see this right by
no, but here's the point. Here's the point. Everything you just said about how complicated it is usually works in the plaintiff's favor in a patent case, because you have this document that was fought over with the patent examiner for 5 years. The examiner at the patent office is an expert in this technology, stamped your patent and issued you your patent, right? And you hold that patent up to the jury.
And they believe that.
That's very strong, right? And then you have your expert to come on and says, and compares the claim to the infringing product and shows you, and then you basically have the other side's expert arguing the other way. And granted, if my plaintiff's experts has no credibility to the jury, that's going to hurt my case. But assuming I pick a good, credible expert, then the defendant's expert has to be really, really much more credible to overcome what the plaintiff's expert is saying. And so at the end of the day, even if the jury says both experts made sense, at some point the jury is going to pick and make a decision, and they're probably going to go with the
But do you think that there is a
plaintiff.
I know that there is a ground, like legal grounds or economical grounds or some other ground to seize some cases from jury trial, or is it like totally?
I'm not sure. I don't know the answer to that, and kind of embarrassed to say that, but I think you have a constitutional right to a jury trial, and I don't think that can be legislated away.
Okay.
We know about amendments to Constitution, and we know.
Yeah, but an amendment to the Constitution is very difficult. You got to get, I think you've got to get 2/3 of the states to agree. I mean, yeah, that's why you never see these things happen, Because, I mean, look how divided America is right now. You ever think you're going to get 2/3 of the states to agree on anything? It's just never going to happen, and you're certainly not going to get them to agree to.
And when you're defending your client against claim,
Against a patent claim?
let's say patent claim or
Yeah.
trademark claim, and we see that plaintiff asked for jury. So what can you do to not brought the claim to the jury, and what can you do? How to assess? How to assess?
Settle.
Yeah. How to assess?
No, you have look. First, the thing you do in any case is you assess your case. Okay? And you have an idea of whether it's a strong case or a weak case. If it's a strong case, you push those issues during settlement, and you explain to the other side how the jury's never going to believe. The issue of jury versus non-jury is almost never really discussed until settlement has totally failed. And then it's, if the defendant has a strong case, what you might be able to do is get the plaintiff, who knows they're going to spend more money on a jury trial, you might get them to agree to a bench trial. But you got to get them to agree to a bench trial. But again, that doesn't happen until, till the end of the day. Now, if you have that strong of a case, you may never get to that question, because if you really do have a strong case, once discovery closes and experts are done with their reports and depositions, you bring a motion for summary judgment. And if you really do have a strong case, you'll probably win on that. And then the case gets dismissed and goes away. And you don't ever have to worry about negotiating anymore with settlement or negotiating with whether there's going to be a jury trial. Although you actually do have to discuss at that point a possible settlement, because you could win on summary judgment and the plaintiff could say, we're going to appeal this. So then the discussion comes up, okay, how much will it cost? How much do I have to pay you not to appeal it? So you still can have some discussions at that point on those issues. But again, it's a very fluid system, and it's changing on a regular basis. I mean, we have a case in the United States. I won't name the defendants or what it is, but we're waiting on a decision from a court now on a related issue. And it may have a significant effect on our case. It may not. We don't know. We're just waiting to see what that court does. And in the meantime, the client's spending a lot of money and time prosecuting the case because it's moving forward. That's just the way it is. It's I don't know what to tell you how to fix and why it is like that, but it is. It's over 250 years of it's developed into this, and I don't see it getting any better. I don't really ever see it getting any better. I don't know what technology is going to do in the future, but technology is not going to replace a jury. I can't see that that's ever going to be able to be allowed to happen.
We can use 12 artificial intelligence
I don't think
instead
that's-
of 12 juries.
No, but it's the you're supposed to be tried to a jury of your peers. I'm smart and I'm good looking, but I'm not as smart as artificial intelligence, etc.
You're smarter.
Yeah, no, well,
Yeah,
You are genuine smart.
yeah.
Artificial intelligence. So we see 2.5 centuries of American history, and what do you think about next 2.5 centuries? How American intellectual property, from your perspective, will look like?
well, it's going to depend significantly on innovation and where it goes. For example, AI. AI is the next biggest question. If AI didn't occur and technology stayed relatively, there were no big, huge jumps and leaps in technology, I don't know that it would change that much, to be quite honest with you, Igor. I think it would probably stay relatively the same. Look, a lot of American law has changed since I started practicing, simply because of decisions in federal court cases has changed the way a statute has been interpreted, and therefore you had to change the way you practice. Or things have changed because the American system, both on the patent side and on the trademark side, we had different terms for how long a trademark lasted before the first renewal was due, and we had 17 years from the issue date of a patent for the life of the patent, and pretty much the rest of the world had 20 years from filing of the application for the patent, and they had 10 years before the first renewal and 10 years for trademarks, and the rest of the world, pretty much, I think, other than Canada and I don't know what other countries, U.S. still requires use of the mark in order to maintain a registration. And for
That's fair. That's fair.
right,
Instead of other
but when I started, it was very the intent to use process was relatively new. Now it's always been something that I've had, but before the filing of a proposed use application, you had to have use in the United States before you could file a trademark application. So that law changed. Because a lot of the case law, a lot of the trials were based upon the use that you said you represented to the trademark office. Was it real use, or was it just nominal use in order to get a registration through? A lot of that case law from 40, 50, 60 years ago was about that, whether or not. And, the courts did bend over backwards to allow ministerial uses to satisfy that use requirement so that somebody could file a trademark application. But with the advent of the proposed use process, all those rulings really went out the window. And the courts were immediately now saying, look, that kind of nominal use was allowed as a contingency to help get the person to file the trademark. But now that you have proposal, you have no excuse anymore. You can't rely on that. Now you have to have real significant use of it. And it took a long time. There were a lot of, there was 5 years of case law while that all developed and people understood the new boundaries and what was required. So how the international community interacts and what the international community will affect then how changes are rewritten into the U.S. laws, just the same way as I'm sure it happens in Europe. If there's a big change, I'm sure the European Union and all those entities, they discussed possible new laws and how to change it to conform to how everything else is going around the world. And so then your laws change also. So that's always going to be a factor. That's always going to be a factor. But then the big factors are what technology comes out. And right now, the big technology is AI. And it's going to be a issue for at least the next 10, 15 years before it gets resolved. And it may not get resolved in the way anybody wants it to over the next 10 or 15 years. That technology is going to continue to expand and get better. And at some point, the two things are going to meet and combine. The technology is going to have gotten to a point where something that is created by AI, as long as there's enough input maybe from the individual, you can patent that or possibly get a copyright for that. And the other thing that I think has to happen is the effect of AI on the world economy. It's not just the United States, it's the world economy. AI can replace many, many, many different positions as we go on. I think it's going to be 20, 30 years until the people who were most affected by AI are no longer in the workforce and no longer alive, and their kids and the next generations are around who have accepted AI and you know, all the economies are functioning with the AI. Once all of that converges, I think that at that point, the laws around the world will start changing to allow. First step will be small. You've got to have, you know, this much contribution by a human entering into the AI, and then we'll allow this output from the AI to be patented.
I also see this very interesting parallel in American history. We saw
Imperialism.
no slaves.
So, there we go. Okay.
So we see it was
That's it. I thought I was getting off. I thought I was giving you a zinger. You got it right back at me. There you go. Okay, go ahead.
because what we see civil war. We see slaves, and we see that slaves are not persons with legal personalities under American law,
Right.
Before Lincoln or in American South during Civil War, and there were different issues that just, all artworks or all technologies created by slaves are not copyrightable, are not patentable because they are not legal personalities, and owners of slaves also can't own it because can't patent it because they are not authors.
They're not the author. They're not the inventors, right?
And now we see artificial intelligence, and you also saying that everything which is created by artificial intelligence can be copyrighted or patented because it was not created by owner, let's say,
human.
of artificial intelligence. Do we see this parallel, and whether it could be the same impact we had in the middle of 19th century, we may have in the middle of 21st century?
Well, the problem for the blacks in America back then were that they weren't recognized as citizens. So they couldn't file a declaration that they were a U.S. citizen, and so therefore they couldn't get the patent. So once that law changed, then all that went away. With respect to AI, I still think you're going to have, I think the only way that that's going to be able to be patented or copyrighted is if there is a significant input. Like, I'll give you an example. I either dictate or I type in an extraordinarily detailed design of whatever it is, okay, of my art. Because I am not an artist and I can't draw to save my life, let's say, I could never put that down on paper the way I want it to be, or on canvas or whatever the heck you do. Seems to me that if I am able to dictate significantly or type it in and then have that printed out, created by the AI and printed out, and then if I still don't like it, can then manipulate the areas of my code, so to speak, that I put in to get that to where I wanted to, I should be able to own a copyright it seems to me, in that, or a design patent in that. Again, I don't think that we're anywhere near getting to that point where that's going to be allowed. It just started. It's just never going to have everybody accepting AI in this world right now as being able to be a patent or a copyright owner. It's got to be at least 5 to 10 years from now before a case like I just said might be able to be brought and might be able to win. I mean, that's my opinion on that. And so for the next 250 years of America, I think there's going to be many changes in IP, but I couldn't even begin to tell you what they're going to be.
What about Artemis Accord, about space, about new missions to Moon and Mars?
Oh, you mean like who owns trademarks in space and stuff?
Right. Oh, but
God, who the heck knows how that's
invented on Mars?
or something that's invented on Mars?
Or
you
that
know?
photo. Did you see that photo which were taken from Artemis 2, like Earth rise over Moon's surface, and so the man who made it, astronaut who made it, what the limits of his copyright?
Did a person take the picture?
I suppose yes.
No, I suppose so.
Well,
Was
the
it-
person
was very
took the
nice
picture.
of-
Look, I don't know what contracts they signed, and anything they probably is owned by NASA. So I couldn't tell you,
So
but
it is in public domain. I remember.
I don't know. I don't know that it would be public domain, but it could be owned. It's like when you sign an employee contract, and you go into a company, and you probably, if the company's doing their crossing their T's and dotting their I's, they're having a contract that says that anything you invent or create is going to be owned by the company. But barring that whole issue for this person who took the photograph, I would think they have. Why is that different than taking a photograph here of any cause?
Yeah, but to own a copyright under the Paris Convention, please, I have to create original of the work in one of the countries, which provides me with the right.
Right.
And when I am, or the person, the astronaut, he or she, I don't know,
Maybe she.
so they are on a spaceship, they could be outside of any jurisdiction. Of course, the ship is under the jurisdiction of the United States, I suppose.
Yeah, I would assume. Yeah, that would be my assumption in that case. I mean, you're right. Could it be challenged?
But what if the picture would have been taken outside the ship in the open space?
Like Buzz Aldrin take a photo of Neil Armstrong outside of Eagle.
Or on the moon, yes.
Yes. Even with American flag.
They were standing on the moon, and the moon is neutral jurisdiction, according to some international treaties and corporations and long.
Well, my guess is they took but you just said it. They took it after they planted the flag, so that was the United States.
So yeah, okay, that's the point.
Because we have flag on their suits, on their space suits.
Yeah. No, because
But
they
if not-
planted the flag.
But if not,
The moon's ours. Go away. Or at least that little piece of it. I don't know. It's a very interesting question. If you have a mark that's used in space,
For instance,
for instance,
the golf.
so
ball,
like can I would assume
or Nutella.
I would assume
Nutella jar.
I would assume China could send up an Artemis. I mean, let's assume Artemis isn't trademarked in China.
For spaceship.
for example,
Could China create and launch an Artemis spaceship?
Could they ban using of the name?
You have the name. Could the U.S. Artemis company ban usage of that name?
the more provocative patient, Anton mentioned about Nutella. If you saw that moment when Nutella, one astronaut threw Nutella to another,
Oh, I didn't see that.
yeah, and there was a moment in space on the other side of the moon when Nutella fly inside spaceship. And so let's assume it was not Nutella, it will be Mutella or Lutella, so something infringing. Something infringing. So in this case, whether it will be infringing, where we can sue, where
See, I would think I would think that you would be able to sue. I don't know who you'd sue.
NASA?
first.
But my guess is
the
it was
prices
just
are-
my guess it was smuggled on by the astronauts. So I don't know who you're suing, but maybe you're suing the company that asked them to smuggle it on and get their brand out there. Yeah, because if it's look, I hear what you're saying. At the end of the day, isn't the question? There's two sides to every party, to every discussion. In that case, there's a company that's making what they pretty much have to know is an infringing name and asking it to be publicized for the world to see on the spaceship. Don't they have to take responsibility for that? Shouldn't there be some kind of reckoning for that? So I don't see why that would be not allowed as for Nutella to sue. Now, who they're suing, I gotta look that, but that's always a huge question at the beginning of any law. So who the heck are you suing?
The question is also about jurisdiction, so whether infringement.
Yeah, well, I don't know about the jurisdiction on that. I would assume it's a U.S. spacecraft where it's happening. You can sue in the United States. I don't know that that's ever been litigated. I don't know what. My guess would be that it should be a United States court that it's litigated in under U.S. law. Couldn't tell you what state it would have to occur in,
Florida, bro.
but
Florida.
or maybe Florida
Where they started.
yeah, maybe.
Or,
But all of
or
that
Hawaii, where they landed.
Or Haas.
No, well, that would all be questions that would have to be. Look, every time there's a new issue,
So
and
that's
you
the
can't
point.
find law on it, you
Right, right.
you
Have to
know,
go to
you-
court.
yeah,
So
you have to figure it out.
Maybe this is the point of creating something new in law in the next 2 centuries and a half.
Well, that could be. But the space programs have been around now since the '60s, so that's never come up as an issue. I guess as space flight becomes more and more routine, look, it wasn't going to happen in the early Saturn launchings because they didn't screw around. They were really strict, and you weren't going to have any of those astronauts screwing around. I mean, it was too dangerous, and it was too new, and there was too much pride in the whole thing. These days, could I see something like we just discussed happening on one of these launches from these many other companies that is now starting to? Yeah. So at some point, something like that is going to happen, and it's going to be an interesting lawsuit. So that could be but that's kind of a new technology. While space travel isn't new, the ability to go and have many companies go and perhaps shooting things into space or creating space stations or going to Mars or whatever, that's all going to be brand new. And then, all that's going to have to be decided. What happens?
Yeah, we heard about hotel, which was announced on the moon, I suppose, in 5 years or in 10 years or something, because it's announced. Also, and I didn't remember. So, but when you was, but you'll be in a hotel and you can buy a ticket. You can book a room there for 2013 or 2015, and you can do it just now.
And never come up there.
Yeah, right. But which is I would think that the U.S. or the country's laws, whichever hotel went and spent the money and had that done or contributed money to have that built, seems to me that they would have the rights, I would think, to the entire planet for that mark at that point for hotels.
For the moon or for the Earth.
Yeah, no, for the moon. I would think that would, to me, that would make sense because, I mean, maybe it's an overly aggressive monopoly, but if Hilton puts the first hotel on the moon, why should others be allowed to use Hilton then on the moon?
But let's imagine, for example, that Hilton put a hotel on the moon, and for example, Chinese hotel operator put something similar to the moon, like Ilton or Pilton, and whether it could be allowed.
Well, that I think would still be. I think that would be an allowable lawsuit, and it would be whether seems to me, I think it would be whether or not the Ilton is confusingly similar for Hilton. I would think. Again, we're all just guessing here. I don't know. What do you think?
I would say that probably they will not have any jurisdiction for that because of the moon.
So you think that
In the modern legal regime, the moon is out of jurisdiction of any country. It's
so you think Hilton's just giving up their name?
I would say that we should have the separate trademark jurisdiction for the moon, like trademark register, for instance. And if you should Hilton first go to the moon or to, I don't know, back to Russia or something like that, you should register a trademark. either on the moon or in Russia or in wherever.
Do you think that the moon's going to have to be, this could take forever. Do you think the moon's going to have to be divided into?
I suppose there will be 30 colonies of Earth on Moon,
And the Boston Tea Party,
and it will be Moon
not-
Boston Tea Party,
not Boston.
and they will proclaim it a new constitution where it will be written that we are protecting the intellectual property and we are protecting our rights by judges and by
50
jury.
years, yes. And we will the juries will be
Yeah, but the funny thing about that is if what I'm saying it ends up being wrong, which certainly could be, all that's going to happen is the Chinese company is going to leave it up and ignore the suits for damages in the United States, and Hilton would not have gotten anywhere as far as that's concerned, right?
And when we have this concept of natural laws, which was about, for example, people of United States can revolt against British Empire because freedom is in the heart of them. It's like a natural law, a natural right which allowed them to revolt against the UK. So maybe we have the same here. For example, Hilton employees on Moon could protect their brand.
employees.
Cosmonauts, guests of Hilton hotel management on the Moon could protect their IP, recognizing it as a trademark there, recognizing it as its natural right.
Yeah, but they don't have any connection to this trademark. They're just
Yes,
either
yes.
employee or
They don't have any connection to American trademark, but the trademark will be in their essence. So like any creativity is specifically connected with natural right of any person to create something. So this will have to be trademark. So Hilton employees who will residents of the Moon who came to their opponents of Ilton and said that you are prohibiting
to come there,
to infringe our rights
to come there.
Yes.
In the United States or in China or there.
on the Moon.
There is no court on the moon.
Yes, and we have jurisdiction where no courts, when persons who could protect their rights physically by their own activities.
With arms.
So with arms, so they can take out all those labels of Ilton because there is no jurisdiction there.
Yes, ladies and gentlemen.
Yeah, now
Igor is now suggesting that there'd be all-out war and violence on the moon to protect trademark rights.
yes. No.
And only after civilization will come and will arrange new laws on the moon, so we will
It seems to me that if we're up there and fighting, civilization has come already. So we should have that all worked out beforehand.
So okay, let's have the last question here. So the America is 250 years right now, and we discussed that it has started from a recognition of the intellectual property for patents and copyrights, like to incentivize.
I mean, from the beginning
From the
of our
beginning, yeah.
Constitution was
Yeah, yeah.
protections for
Yeah,
it.
it was
Not that the war started because.
Yes, yes,
Okay,
yes,
let's really get that clear.
Like it was a fundament of one of the fundaments to incentivize all of this patents and innovations and all of this.
Correct.
And what do you think was the value of intellectual property in the modern America? Like how the intellectual property impacted of what America become?
Oh, I think it's huge, and I think it will always be, and I think it should always be, because without the ability, look, in at least the capitalist system, without the ability to protect what you create, nobody's going to create. I mean, look, there'll always be some people that will anyway, but the vast, vast, vast majority of people are not going to spend their time and energy creating something that they know they can't make any money off of. I mean, that's the whole.
But for instance, Soviet Union was completely different. No one owned any right. Like the only thing you got from your innovation in the Soviet Union was like the recognition you're an author and probably some additional money, like one-time payment for your innovation.
But you got something anyway. May not be what we got in the United States, but for the people in Russia at the time, it was enough to incentivize them. Correct?
Correct.
That's the point. That's what it is. It's without it, totally without it, or that even, or anything, you have no incentive and you're going to lose out on a lot of creation. And so I think it spurs innovation, and I think it spurs art. If I'm an artist and I create something and anybody can create it and put it on t-shirts and everything else,
Why would you?
yeah, it's tough to make a living as an artist to begin with. That is totally taking it away from everybody. So I think it's a good system. Look, does it have problems? Everything has problems. Of course it has some problems. But I think it works for the most part. Are there bad court decisions? Yes. Are there bad plaintiffs or defendants? Absolutely. But over time, I think it's a working system that we need, and it's a good system. So I have no problem with it at continuing and staying pretty much the way it is.
Yeah. Thank you for this discussion, and
Happy Independence Day.
Yeah.
Yay!
All the creativity and all.
yeah, and we will see what's the next podcast about the 500th anniversary of the United States will be. I assume that this podcast will be created totally by the AI and for AI, and no one will, I wouldn't say exist, but no one will listen to podcasts and create podcasts except for the artificial intelligence in 200.
Okay, my opinion on this is that, and this will depend upon you people out there. I mean, if we get a lot of hits on this, okay, the three of us will be back in 250 years because we're going to freeze. We're going to get frozen.
We'll place
And we'll
our consciousness in the
we'll
artificial
do
intelligence.
another one in 250 years. So you get out there and
Yeah, wait.
See you in the
Wait.
future.
Yes.